Okay, so, I've written this book called The Schoolhouse Gate, and it's a long book. It's 576 pages. I like to think that it's a crisp 576 pages, but it's 576 pages nevertheless. And so one of the questions I often get is, how long did it take you to write this thing? And the answer to that question is that it's either 4 years to write or about 3 decades to write, depending upon how you look at it, right? So the 4 years are not long after I moved to Chicago. I turned my focus to education law and started writing that in earnest. But the origins of the book go back to my time growing up in Washington, D.C. I grew up in southeast Washington, D.C., a predominantly black neighborhood. And I never went to my local schools. Starting in the 5th grade, I traveled from far southeast D.C., east of the Anacostia River, to way upper northwest Washington, the most privileged segment of Washington, D.C. And in order to make that journey, I got on a bus and got on 2 different subway lines and then walked a pretty long way to John Eaton Elementary. And so this is when I'm about 10 years old. And like any 10-year-old, I'm thinking, why in the world am I waking up so early to go to the 5th grade? And what opportunities am I acquiring as a result of this long daily journey? And importantly, what opportunities are my friends from my neighborhood not gaining as a result of going to our local public schools? I can also remember when I was in the 6th grade, my father leaving from home very late one night or maybe early one morning in order to go sort of park his car outside of Alice Deal Junior High School, also up in way northwest Washington. That is because they took students from the district, and then for the remaining spots, one was forced to queue up, right, in order to get admission to the best junior high school in Washington, D.C. And so my father goes to sleep sort of fitfully in the car one night in order to, make this come true. And that should simultaneously be inspiring and depressing, right? It's inspiring in the sense that, a committed parent can make an enormous difference in their kid's life, but it's also depressing in the sense that it shouldn't require these sorts of superhuman sacrifices, in effect sleeping outside in order to get your kid admission to a fancy school, a fancy public school. I'm quite confident that without those sacrifices, I would not be standing before you today. So I thought that what I would do is to talk a little bit about the broad overview of the book, and then I would talk about the issues that are entertaining me most right now and that I care the most about, and then we would open it up to questions and comments and also objections. So I truly do look forward to this being a conversation. So I view the book at the broadest level of generality as being an examination of the intersection of 2 important American institutions, the public school on the one hand and the Supreme Court on the other. And the core claim of the book is that it's difficult, if not impossible, to understand the one institution without thinking about the other. So we don't often think about public schools as being legal institutions. Nevertheless, when one steps back and looks at the whole host of constitutional rights that the Supreme Court of the United States has crafted and refined for public schools, it becomes clear that the Constitution of the United States shapes what happens in the nation's public schools in a significant way. And so one goal for the book is to offer a panoramic view of the wide array of constitutional rights that exist for students in the nation's public schools. And so I have chapters on the freedom of speech. I have a chapter on religion, thinking about free exercise and also the Establishment Clause. I have a chapter on discipline, thinking about suspensions and also corporal punishment. I have a chapter on criminal procedure, so thinking about the Fourth Amendments and the Fifth Amendments. I have a chapter on Brown versus Board of Education, of course, right, the Equal Protection Clause. And I also have a chapter on some of the other battles surrounding the Equal Protection Clause. I should also say that Brown versus Board of Education is the single most important decision in the 20th century, if not the nation's entire history. Indeed, now Justice Kavanaugh made that claim during his confirmation hearings. It was more important for him than even Marbury versus Madison. And I remember learning about Brown versus Board of Education as a 10-year-old in Washington, D.C. And it also sort of drove home for me that there's often a big gap between law on the books and life in the streets. That is to say that there are many schools within shouting distance of the Supreme Court that are all black, right? The Brown versus Board of Education may as well be a rumor. And that sort of inspired me to undertake this project. Another source for this project, thinking about the public schools, is that I graduated from college and I thought I was going to be a public school teacher. I got certified to teach public school at Duke, and I taught US history and I taught civics. And at the time, I had only a very vague sense as to what students' constitutional rights actually meant in school. I think I would have been hard-pressed to identify Tinker as the leading free speech case in the public schools. And so, one explanation for my lack of understanding is that I was unusually and powerfully ignorant. That's a completely plausible explanation. But another one is that there are many teachers out there who are interested in students' constitutional rights but have difficulty accessing that information. And so one of the goals of the book is to render in an accessible way the origins of students' constitutional rights, the contours of those rights, and then also to offer my vision for how things should shift going forward. I published the book with a trade press rather than an academic press so that non-lawyers could understand it. I want law professors to read it, but not only law professors. I view myself as trying to democratize constitutional law. Some people raise the barriers to entry, and I think that there's real value in making it simple. One of the best interviews that I've had is by a high school student in New Jersey who is a junior. And she read the book, and she had this very sophisticated understanding and asked smart questions and sort of pushed back. And I thought, mission accomplished, Now, she is a Supreme Court nerd. She runs a website called High School SCOTUS, so I don't mean to suggest that she's a representative figure, but it can be done. Okay, so that's thinking about the public school. The other part of it is to think about the Supreme Court and its role in American society. I've thought of myself as a constitutional law professor for the last 10 years, and I've written a lot of papers about constitutional law, but I noticed that when I was trying to explore some constitutional phenomenon, I was often attracted, almost inexorably, to education cases. Unlike many constitutional law professors, I think that the Supreme Court has played an important role in shaping American society, including in protecting minority rights. Many constitutional law professors suggest that the Supreme Court is a mere reflector of American society, that it is marching in lockstep with the American people, and then when it tries to defend minority rights, it ends up making matters worse. I think that is an overstated view, and so one of the goals of the book is to identify instances where the Supreme Court has made an important contribution to defending minority rights. Let me give you a couple of examples to put some flesh on the bones here. There's an idea that constitutional law professors have that they speak about the Supreme Court as invalidating constitutional outliers. This is the claim that often the Supreme Court is not invalidating measures found all across the country, but instead found in one or two, or at most a handful of jurisdictions, right? And so they say it's a mistake to view the Supreme Court as making an important contribution to our constitutional order when it invalidates outliers. I think that's a valuable contribution in the sense that we need to be aware of the legislative landscape rather than just assuming that when the Supreme Court invalidates a measure that it changes everything under the sun. Nevertheless, there are some instances where the Supreme Court invalidates a measure that's found in only one state and that it's still possible to see it as making a valuable contribution to our constitutional order. I say that there's a distinction when you're thinking about a broad term like outliers between an upstart on the one hand and a holdout on the other. When the Supreme Court is invalidating a holdout, it's invalidating a practice that may have once been widespread but has retracted to a small number of jurisdictions. That's quite different than invalidating a practice when it is the first in the nation to adopt the practice. Just because it was the first does not mean that it would be the last. An example of this phenomenon would be in the great state of Oregon in the 1920s, in a case called Pierce versus Society of Sisters, where there's a referendum that says we want to get rid of private and parochial schools. That referendum was passed and became, governing law. It was a referendum that was pushed by the Ku Klux Klan. The people who were a source of concern would have been Catholics. The idea would have been that Catholics attending Catholic school are not becoming Americanized. The Supreme Court invalidated that practice, that it violates the Constitution, and in the course of so doing, it took that item off of the legislative agenda in several other states. Other states were paying attention and would have followed suit. Another issue follows a similar pattern, and I'm thinking here about Plyler versus Doe, a case from 1982. Texas has a statute that says it's permissible to exclude unauthorized immigrants from Texas public schools. Texas is the only state in the nation that has this, and that leads some law professors to say, oh, sure, they invalidated the practice, but it's of no real import. In effect, that this statute would have appealed only to those cowboys down in Texas, right? That people who are on the border would have been particularly sensitive about this issue. That is, in my view, an implausible understanding of Plyler versus Doe. I found polling data that suggested that a majority of Americans thought that these sort of laws should be permissible. And we know very well today that anxiety about unauthorized immigration is far from confined to the nation's border. And so you can agree with the Plyler versus Doe decision or disagree with the Plyler versus Doe decision, but there's no doubt that it made an important difference in the sense that it allowed millions of people to receive an education who otherwise could have been denied one. Okay. That's a nice exclamation mark. Okay, that's a nice transition. I'm going to talk about these three topics that I care about particularly and that I hope that you'll care about as well. The first is the freedom of speech. The second is the Fourth Amendment, thinking about unreasonable searches and seizures. And the final issue that I'll speak about is corporal punishment. Okay. So, freedom of speech. I said a moment ago that Tinker is the foundational case in this area involving student speech. In 1965, in Des Moines, Iowa, there are students who want to wear black armbands to school in protest of the Vietnam War. The school gets wind of this and says, oh no, this is too hot of a topic. We had a graduate who died over in Vietnam, and he still has buddies who are here. And if you wear these black armbands, his friends are going to take it as though you are dishonoring his memory and indeed his sacrifice. In order to keep the peace, we are going to tell you you cannot wear these black armbands. And the question is, does this violate the freedom of speech? The Supreme Court of the United States answers this in the affirmative and says, yes, this violates the freedom of speech, that students have rights. Justice Fortas writes the opinion for the court, and it is a magnificent opinion. It gives me the title for my book. He says, it can hardly be argued that students shed their constitutional rights at the Schoolhouse Gate. And it's an important opinion in part because he reconceptualizes the role of students in society. He says that America is an often disputatious society. People like to mix it up, right? You can almost hear echoes of Tocqueville's notion of the clamor that defines American society. And he says it would be odd if our public schools did not evince some of that same disputatious character. He says that students speaking to one another on the issues of the day is not a distraction, but instead a vital part of the educational process itself. This is an opinion that's handed down in 1969, and when the initial speech happens, it's 65. This is long before the rise of mass mobilization against the Vietnam War. And so it was a really open question as to whether this right would be recognized. As if to underscore this idea that America is a disputatious society, Justice Hugo Black wrote a vehement dissenting opinion in this case. He spoke from the bench for more than 20 minutes, signaling his disagreement. Generally speaking, when Supreme Court justices write dissents, they simply publish them in U.S. reports, and that's the end of the matter. So he felt very strongly. He said, I want it known that I disavow any sentence, any word, any part of what the Supreme Court does today. He was fairly frothing at the mouth as he said this, so much so that Chief Justice Warren is purported to have said, old Hugo really got caught up in his jockstrap on that one. And if he did get caught up in his jockstrap, some people have suggested that it's an event from his personal life. He had a grandson who produced an underground newspaper that was critical of school administrators, and they suspended him. And we find a letter from Hugo Black to his daughter-in-law that says, the school did exactly the right thing here. Ours is too permissive of a society. There are young men with long hair these days, and we need to restore order. Students are there to be seen and not heard, right? This is an irresistible anecdote for people who write about Tinker, and indeed I include it in my book. Nevertheless, it's my view that it is mistaken to view Black's dissent as merely one elderly grandfather's fit of pique. I found polling data that suggests that Hugo Black spoke for a majority of Americans, far more Americans than did Justice Fortas's opinion. There was a poll from Harris that said, should students have the right to be able to do their protests? And only 38% of respondents answered yes, they should be able to do their protests. And of course, it's worth saying that the students who would have most readily sprung to mind would not have been high school students, but college students. This is a time of Mark Rudd and Students for a Democratic Society and the unrest that took hold in many college campuses. And so if there was that low of a support for college students to make their protests, imagine how low the level of support would have been for high school students. Okay, one of the things that I try to do in the book is to spotlight the stories of the litigants and their families who bring these cases. One of the things that struck me was that it required a tremendous amount of courage for students to bring these sorts of claims because they are standing up not only against their school administrators, but also their surrounding communities. And that was certainly true in the Tinker household. The Tinker household was flooded with prank phone calls or anonymous phone calls, threatening phone calls, letters saying truly noxious things, and even the Tinker front door was splattered with a bucket of red paint. The evident implication was that only a communist, a red, would dare to oppose the Vietnam War. When I was a law clerk at the Supreme Court, there was also a free speech case. One of the claims in the book is that the Supreme Court did a solid job of protecting students' constitutional rights for a period of time, but in the more recent decades, it has fallen down in its responsibility for vindicating students' rights. There was a case that was decided in 2007 when I was there. It was called, the formal name is Morse versus Frederick. Nobody calls it Morse versus Frederick. Instead, everybody refers to it as bong hits for Jesus. Right? This is a slogan that is on a 14-foot-long banner that a high school senior in Juneau, Alaska, unfurled. The Olympic torch is making its way down the Olympic torch in Juneau, Alaska is making its way down Glacier Avenue. And some teachers let their students out of class in order to witness this momentous event. Joseph Frederick, he's an 18-year-old high school senior. He doesn't quite come to school that day. He comes near the school. He stations himself directly across and unfurls this banner, bong hits for Jesus, right? What does that mean, right? The principal sees this banner, marches across the street, grabs it out of his hands, and then proceeds to suspend him from school. And the question is, does this violate his freedom of speech? Many of you seem to think that the answer to that question is yes, judging by the way that you're sort of contorting your faces. The Supreme Court said no, it doesn't violate his free speech rights. It's a very unusual opinion. Chief Justice Roberts writes the opinion for the court. And he says, if the educator reasonably believes that the speech in question is designed to promote illicit drug use, then it's permissible to punish the student for the speech. He says that high schools have serious problems with drug abuse, and we would be, in effect, foolish to take this weapon from the quiver of school administrators. It's highly unusual from a First Amendment perspective because it is a hallmark of the freedom of speech that you're supposed to be neutral with respect to viewpoint. You're not able to silence one side of the debate without silencing the other side of the debate, because the idea is that in the marketplace of ideas that these ideas will be debated and the truth will out. Justice Stevens wrote a powerful dissenting opinion in the Bong Hits for Jesus case. He was quite elderly at the time. I'm happy to report he's more elderly still today, so he is still with us. But he said, I can remember the days of prohibition. And why should we not view Joseph Frederick as attempting to participate, however inarticulately, in a growing debate about the legality of marijuana? And the force of the analogy to prohibition is that what is illegal today can become legal tomorrow, and how does that work but for people making their claims known? And, it seems to me that with now the passage of 12 years' time, that Stevens' argument assumes only added significance. All right? There's been a transformation with respect to the legality of marijuana in many states around the country. I was just in California not that long ago after a talk, and a fellow law professor, we're walking down the street, and he took out this pen and said, "Do you smoke?" I was shocked by this, and I said, "No, thank you." But things have changed dramatically on this score. So that's one instance where the Supreme Court has fallen down, and we can talk more about other areas where the Supreme Court has fallen down with respect to freedom of speech in Q&A if you're interested. The second case I'll be briefer on, that is the Fourth Amendment, thinking about unreasonable searches and seizures, and in particular thinking about suspicionless drug searches. Lindsay Earls was in a high school in Oklahoma. She's in her first period class. She is summoned to the girls' restroom and told that she has to give a urine specimen. She participates in extracurricular activities, and as a result of doing that, she is open to being required to offer a urine sample. So she talks about being with many other students in the girls' room, having a teacher posted outside listening for the telltale sounds of urination. She emerges from the stall, hands the vessel to the teacher, who inspects it for warmth, and then holds it up to the light in order to look at it for color and clarity. And Lindsay Earls claims that this violates her Fourth Amendment rights against unreasonable searches. You would think, under a traditional perspective, that this would violate the Fourth Amendment because this would be a dragnet search, right? Where the government, in effect, is just sweeping up lots of information and seeing what it can find. The Fourth Amendment disprefers these sorts of speeches. As you can imagine, the intrusion into an individual's liberty is great and widespread, and the likelihood of finding any wrongdoing is very low. And so you would think that the Supreme Court would invalidate that, but no, they decided to uphold the search. And again, they said that drugs are a special problem in schools, and so we're willing to give them, in effect, the benefit of the doubt. Here, too, Lindsay Earls was a quite remarkable person. She grew up about 40 miles away from Oklahoma City, a relatively remote part of Oklahoma, and her family and her integrity was sort of insulted. People said that the reason she was bringing this lawsuit was because she had lost sight of her Christian faith. They said that, and this is a charge that carried real venom, right, in her part of Oklahoma. They said that she was merely a druggie and she wanted to be able to, use drugs, and that's what's really motivating the search. Maybe no surprise that these sorts of things appeared in newspapers and over the airwaves in Oklahoma, but even in Washington, D.C., at the Supreme Court of the United States, her family was also brought in for some abuse. That is to say that Justice Kennedy, who during oral argument when I was a law clerk there was pretty sober and even-keeled. He didn't tend to get emotional. And during this oral argument, he turned red-faced with emotion as he said, the only people who would want to send their kids to a druggy school are you and your client. You know? So this is a testament to the way that these cases have an unusual ability to get people's blood boiling over these matters. Okay, the final case I'll speak about is the one that I care the most about. And it's the issue of corporal punishment. So James Ingram is a middle school student in Miami, Florida. He goes to a school called Charles R. Drew Middle School. And he's on a stage at a school assembly, and he's instructed to leave the stage. And he does so with an insufficient sense of alacrity. And for that pretty garden variety instance of misbehavior, he is summoned to the principal's office where he's supposed to receive 5 licks in the parlance. This is 5 blows with a 2-foot-long wooden paddle. And when his turn arises, he protests his innocence, and there are 2 assistant principals who grab him and bend him over the principal's desk. One of the assistant principals is holding his arms down, and the other is holding his legs down. And he receives not 5 licks, but 20 licks. This beating, for lack of a better term, is so savage that he seeks and receives medical attention. And a doctor prescribed pain relievers, sleeping pills, cold compresses, laxatives. He returns, James Ingram does, a few days later and I found a doctor's notes that noted a bruise that was 6 inches in diameter, that was tender, purplish, swollen, and also oozing fluid. It's more than 2 weeks before James Ingram is able to return to school, and about 3 weeks before he can sit down without experiencing discomfort. And this is part of a larger reign of terror that existed at Charles R. Drew Middle School, where students were beaten for having untucked shirt tails, for sitting in the wrong seat. And sometimes there were just mass paddlings where they would say, you all in the back are acting up, and therefore the whole class is going to get it. Anybody know who Charles R. Drew is? I've said that a couple of times. Please, tell me who Charles R. Drew is. This is terrific.
First black doctor in the United States.
I don't know if that's true, but you are correct. He's a black doctor. I did see another hand up and everything, so is there somebody else? Yes, sir, in the back. Okay, terrific. So that's right. Dr. Drew did pioneering work in the area of blood transfusions, right? So sort of the blood bank and everything. And this is important because we're at an all-black school in Miami, Florida, right? White kids didn't go to schools named after black kids in Miami, Florida. And in the school's district's effort to defend the practice, they ended up making matters worse. That is to say that there is a principal of a school in Miami Beach who said, we don't use corporal punishment in this school. We have a predominantly Jewish population here, and they understand oral persuasion. The unmistakable implication here is that the black students at Charles R. Drew Junior High School understand only brute force. And so if you're a lawyer and you're trying to bring a claim that this violates the Eighth Amendment's prohibition on cruel and unusual punishment, you'd be hard-pressed to identify a more egregious set of facts, right, that call out for the court's intervention. And indeed, a few years earlier in the federal courts, corporal punishment, use of what was called the strap in prisons, had been gotten rid of, where you could effect flog a prisoner for disobeying orders. And so people thought, if you can't hit someone who's been convicted of a crime, there's no way in the world that you'll be able to hit a public school student. That's not how the Supreme Court of the United States saw it in a 1977 opinion. Justice Powell wrote, it was a 5-4 decision. And Powell said that this doesn't violate the Eighth Amendment because this doesn't qualify as punishment for purposes of the cruel and unusual punishment clause. He says that in order to qualify as punishment, it has to be punishment that stems from a criminal conviction. Yeah. And so there was no relief there. There was also a due process claim, by the way, where they would say before you can get corporal punishment, you have to go through some sort of notice, an opportunity to explain yourself. This is a serious discipline mechanism. That's what it's called. And a few years earlier, in a case called Goss versus Lopez, the Supreme Court of the United States acknowledged due process rights before students were suspended. And so people thought, again, if you get due process before you're suspended, surely you're going to have due process before you can be beaten. And that's not how the Supreme Court of the United States saw it. Justice Powell says if it's egregious enough, you can go to the state courts and you can get some relief on that front, some damages, money. Okay, so I care about this issue most today because it is not merely a historical artifact. Corporal punishment continues to exist in this great nation of ours. There are 18 states that permit corporal punishment. In some ways, that overstates its prevalence. Just 5 states, all located in the South, account for more than 70% of the instances of corporal punishment. Those 5 states are Alabama, Arkansas, Georgia, Mississippi, and Texas. It will come as no surprise to many in this room that students of color receive a disproportionate share of corporal punishment. And so if I have any single hope for my book, it's that it elevates the salience of this issue and that it invites the Supreme Court of the United States to invalidate this practice. And I say the Supreme Court of the United States because I fear that the jurisdictions that retain the practice at this late date are not going to abandon it of their own volition. Okay, so when I was writing some of this book, I thought that my old boss, Judge Garland, was going to become Justice Garland, right? That did not come to pass. People did not give President Obama's last nominee to the Supreme Court a hearing, and it's a shame. And so, nevertheless, I think that all hope is not necessarily lost, even with respect to the current Supreme Court. When you step back, and now I'm going to try to braid together the 3 issues that I've spoken about, I think it's possible to come up with a coalition of liberals and the libertarian-inflected vision of constitutional law that is ascendant in some right-leaning circles to cobble together 5 justices to bring about reform when it comes to the freedom of speech, unreasonable searches and seizures, and also corporal punishment. And when you think about freedom of speech, the traditional sort of libertarian position is that the state should not be able to control what individuals say in the first instance. There should be an ability for people to be able to disagree. With respect to the Fourth Amendment, unreasonable searches and seizures, I found some libertarians at the time who thought that this was an outrage. The idea that simply for participating in an extracurricular activity, you can be required to hand over this information, for lack of a better term, is astonishing. And then finally, and most vividly, libertarians should be embarrassed and appalled by the existence of corporal punishment. In what instance is the state exercising dominion over an individual in a more profound way than taking a foreign object and hitting the person with that object? Kavanaugh referred to himself as a textualist during his confirmation hearings, and boy, there's nothing in the text of the Eighth Amendment about cruel and unusual punishment that stems from a criminal conviction. And so, not all hope is lost, and it's incumbent upon us, I think, to try to find some common ground, even in these very divided times. Okay, There are some of you I know out there who disagree with what I've said and believe that, that students shouldn't have constitutional rights, in effect. And you should find some comfort in the fact that you have agreement in high places. Judge Richard Posner, the mighty Judge Posner, wrote an opinion in 2008 dealing with the freedom of speech. And he took a pretty jaundiced view of these sorts of issues. He said, a heavy federal constitutional hand on the regulation of student speech by school authorities would make little sense, because the contribution that kids can make to the marketplace in ideas and opinions is modest. Okay? His colleague, Judge Alana Rovner, is not nearly as famous as Judge Posner. Judge Posner, for those of you who don't know, is one of the titans of the post-World War II era of legal thought. You know, you don't get to 5 people who are more important than Judge Posner. He is, you know, a mighty figure. Judge Alana Rovner would not traditionally be considered in that same, you know, venerated company. Nevertheless, in this case, in my view, she gets much the better of the argument. And it's with her words that I will leave you all today. She says in response to this student speech case, she says, youth are often the vanguard of social change. Anyone who thinks otherwise has not been paying attention to the civil rights movement, the women's rights movement, the anti-war protests in Vietnam and Iraq, and the 2008 presidential primaries, where the youth voice and the youth vote are having a substantial impact. The young adults to whom the majority refers to as kids and children are either already eligible or a few short years away from being eligible to vote, to marry, to serve in the military, and to be tried as adults in criminal prosecutions. To treat them as children in need of protection from controversy is contrary to the values of the First Amendment. Thank you very much.
We will now open up some space for some Q&A. So if you have a question, please just raise your hand and I'll bring a mic to you. Please don't feel shy. Thank you, Ted. Start with
Hi. Ooh. So I wondered if you might address the issue of hate speech and how that is curtailed or not in terms of its impact on people and how to judge when there's hate speech and other types of curbing of speech. And in addition, how that's impacted, especially for public institutions, since I'm a communications person, on social media and how you address that issue there.
It's a really important question about the boundaries of the First Amendment in effect here. And I am sensitive to these concerns. I would, in my ideal world, there would be some sort of acknowledgement of the special contours of the public schools, and that there is, in some sense, that that schools are places where students are a captive audience, and so they don't have the ability to be able to move around and get away from speech that they don't want. And sometimes this issue does come up with respect to T-shirts and everything. So I don't want to say that the First Amendment, which protects a wide range of speech outside of the public school and the public park across the street, is exactly the same as in the public school. That would go too far from my perspective, and indeed I advocate what I think of as a beefed up notion of the fighting words doctrine in public schools. So if people are using racial epithets and these sorts of words, the school does not need to tolerate that and indeed should be able to punish the students for that speech. In my view, however, the public schools have done an insufficient job of protecting even speech that I disagree with, but that stops short of using that sort of language. So let me give you an example. There's a case involving a student in Southern California who the school wants to have a day of silence in honor of gay equality. And the student is a religious student, and he disagrees with this message. And he wants to wear a T-shirt that says several things, including citing Romans 1:27. And he says homosexuality is a sin. And he says our school accepts what God has condemned. Now, I disagree vehemently with that speech, and I have no doubt that that sort of speech causes an enormous amount of pain to our gay brothers and sisters. Nevertheless, I also think that he should have been able to wear that T-shirt to school, and that his fellow classmates should have told him what they think of that sort of statement. You have to bear in mind that his message is not, as some people have suggested, he should have wore a T-shirt that said straight pride. His message is a religious one, and he says homosexuality is a sin. I cannot think of how he could express that viewpoint with other words that would have avoided running afoul of the school's censorship. And so it's important to bear in mind that this student is, in many respects, in a position like the Tinkers were in the 1960s, which is to say they were expressing a minority viewpoint that many people found upsetting and indeed unpatriotic and deeply misguided. And in my view, the school, Tinker was a good first step, but it did not go far enough. The rule out of Tinker says that if there's a reasonable forecast of a substantial disruption, then it's permissible to punish the student for the speech. The problem with that is that it bakes in what we can think of as a heckler's veto into the doctrine. This is a term that the great Harry Calvin of the University of Chicago Law School invented, where he said that particularly sensitive listeners can, if they object vociferously enough, silence otherwise legitimate speech, right? If they say, I'm going to beat you up over there, then the principal can say, there's a reasonable forecast of a substantial disruption. And this comes up, by the way, including in cases out of California, Northern California, on May the 5th, when there are students who want to wear clothing featuring the American flag. And they say you have to turn the clothing featuring the American flag inside out. Why? May the 5th is AKA Cinco de Mayo. And there are students who are saying, what's the matter? You're wearing this American flag. You don't like Mexicans and these sorts of things, right? I think that while I understand the students' frustration, I think that it would be much better to punish the students who are threatening violence on their fellow classmates rather than the students who are engaging in what I regard as legitimate speech. Okay, that's a very, very long-winded answer, but it's an important question. I wanted to engage it. There's another question right here on the front row. We've got it. Oh.
But I would like to push back a little bit on that to ask, isn't the Supreme Court's concern that is the management of these areas, in the sense that if you don't give the administrators a broad-based authority, then either side is capable of taking this controversy, all the way back to the Supreme Court. So once you acknowledge that there is a limit, then who decides that once you take it outside of the school system?
Yeah. Well, if I understand the question correctly, there was a long hesitation on the part of the federal courts to get involved in this area. The claim for a long time was that we are judges, we are not teachers, we don't have any real expertise in this area, and so we should be hesitant to get involved. Indeed, that was the driving force in an opinion from 1940 called Gobitis, which dealt with requiring Jehovah's Witnesses to pledge allegiance to the American flag. Justice Frankfurter writes an opinion for the court that says, this is fine, this doesn't violate the Constitution, and we can't get involved in this area. Because if we do, it would turn us into the school board for the nation, he says. That way of thinking was rejected by Justice Jackson in the Barnett opinion for 3 years later, where he says we cannot, because of modest assessments of our expertise, refrain from vindicating constitutional rights when they are infringed. He says, if there's any fixed star in our constitutional constellation, it is that no official, high or petty, can prescribe what shall be orthodox, right? And that's an incredibly important opinion, and the Supreme Court has, I think, a responsibility, along with the federal courts, to craft rules that mean that the Constitution is not a dead letter within the public schools. Justice Jackson is my hero on this front when he said that if we abandon our responsibility here, we risk transforming our foundational document into a meaningless sense of platitudes. He says we risk strangling the free mind at its source. And so this is the first sustained exposure that students have to governmental officials, and I think that they need to have some sort of rights there as well.
So let me just continue that sort of line of thinking for a moment. So one of the things that ties all of these things together, or most of these cases, is, and I'm not an expert in constitutional law, but it feels like within the school walls, you can do things in each of these cases, whether it's corporal punishment, search and seizure, or freedom of speech, that you would not be able to do outside the walls of the high school or elementary school. And I guess, you've given a couple reasons, but not a complete reason about why the court over time believes that sort of the Tinker rule, which is of itself a special rule, right?
Mm-hmm.
Normally we don't think that just the threat of disruption is enough to limit the constitutional right. But the rules are obviously so Posner's rule, which is the marketplace of ideas, that basically which is disrespecting the value of the ideas of young people, or the idea that we don't have the expertise. But is there something more? Is there anything that is a better? Neither one of those seem like they're even remotely good reasons. Mm-hmm. Is there ever been a theory, or do you think there is a theory for treating schools differently under the Constitution than similar behavior outside the schools?
Yes, it's a very important question. It seems to me that to import constitutional rights as they exist in the public park, to use the clearest example, wholesale into the school context would create some real difficulties. For the reason that I identified, the sort of captive audience concerns with respect to the freedom of speech. And then certainly there are, school safety concerns that exist as well, including with respect to the Fourth Amendment, which is somewhat diminished. And that's how these things typically work, where students have diluted constitutional rights in the school in comparison to what they have in the public park across the street afterward. But that is better, in my estimation, than not acknowledging their constitutional rights at all. It seems to me that it would teach students a very dangerous lesson about a sort of all-powerful government if we were to say that they have a meaningless constitutional rights. The one exception to the diluted form of constitutional rights would be with respect to religion, where the Establishment Clause actually assumes a more powerful form. You can view the students as receiving almost sort of, Establishment Clause rights on steroids to be free from the sort of indoctrination that exists there. And, I think that approach is I think that these approaches generally are sensible. It's just that in more recent decades, the Supreme Court has fallen down in vindicating some of the principles that it has identified.
So let me. The book was about public K through 12. Now, obviously, we're sitting in a public university. Do any of the arguments that you would think would justify a different approach with regard to education in K through 12 apply here, or should public university, the role of constitutional rights in public university just be the same as it would be if you were in the park?
It's a very interesting question, and one issue that the Supreme Court and the federal courts have basically dodged is should the rights become stronger the older the students that we're talking about, or should we view elementary and secondary students as being indistinguishable? The court has traditionally treated them as though they are indistinguishable, but one could imagine a plausible argument that high school students should have, greater free speech rights than students who are in elementary school. And to continue the analogy, you could imagine that in the world of higher education, that those rights would be much more powerful still. Many of my colleagues in legal academia have spilled a lot of ink writing about higher education, and that is all well and good. People write lots of works about the academic freedom and affirmative action and thinking about admission to higher education, but precious little attention has been paid to K through 12, and so I try to keep the focus there. Let me identify one issue that is especially important to think about, and that is the use of race-conscious classifications and everything, right? This is an issue that we think of as affirmative action in higher education. When I was a law clerk at the Supreme Court of the United States in 2007, there was a case called Parents Involved in Community Schools, which dealt with Louisville and Seattle having voluntary integration programs where they say we want our schools to reflect the rich diversity that exists in our cities. And if we simply assign students to their local schools because of the persistence of residential segregation, there is going to be racial isolation in the schools. And so in order to counter that, we're going to take account of race and send people to school in order to bring them together. The question for the court was, in effect, what does Brown versus Board of Education mean? And Chief Justice Roberts wrote an opinion where he says that these programs violate Brown versus Board of Education. He says, in the bad old days, students were told where they could go to school based on the color of their skin. These programs tell students where they can go to school based on the color of their skin, and it mattered not one whit for constitutional purposes that the modern programs were designed to bring people together, and the programs that existed in the bad old days were designed to keep people apart and, we should say, people of color systematically subordinated, right? My old boss, Justice Breyer, wrote a very long dissenting opinion that was utterly convincing, at least to me. It did not carry the day, but he said to view and compare Louisville and Seattle of today to Topeka, Kansas of the 1950s is a cruel distortion of history, and you don't understand what Brown versus Board of Education was about. I bring this up because this hard version of color blindness could well be making its way to the higher education as well. That is to say that Justice O'Connor wrote an opinion for the court in 2003 upholding the legitimacy of affirmative action. And she said, it's been 25 years from our first action in this area, and we'd be surprised if in another 25 years that we still needed affirmative action. At the time, many advocates of civil rights thought, what do you mean 25 years? We're not there yet and everything, right? That's too short a window. Here we are in 2019, 9 years away from that, and I think that many advocates of civil rights would leap at another 9 years. That is to say that I fear that affirmative action's days are numbered. Okay. Okay, thank you.